Hi, welcome to another edition of This Issue. My guest this time is Orlando Delogu, who's been on the show before. We're talking about a new book that he's just written called Maine's Beaches Are Public Property. Welcome to the show, Orlando.
It's good to be here, Bruce. Thank you.
Great to have you with us today. Introduce yourself a bit for the audience, will you?
Well, I taught at the law school, University of Maine School of Law in Portland for about 40 years full time. We came to Maine, my wife and I and our family. We have 4 children. They all went to public schools and they're doing well. After 40 years of full-time teaching and working with various legislative committees over the years, served on the Portland City Council, served on the Portland Planning Board, served on the Environmental Improvement Commission at the state level dealing with environmental laws, and that's what I do a good deal of, and I'm still doing it. The book deals with a land use, environmental type of issue. I became emeritus professor. That allowed me not to have to be on any committees anymore, and it allowed me to do more research and writing. And we had been participating in these intertidal land cases from about the mid-'80s right up to the present. And I'd made a number of arguments as in the form of amicus briefs to the law court. And I thought I should pull all those together because, in my view, Maine has gone down the wrong road on the issue of public uses of the beaches and intertidal lands, and on the basic question of who owns these lands. We followed Massachusetts law, but Massachusetts law is not followed anywhere else in the country. So now Maine and Massachusetts are 2 outliers. The rest of the coastal states take the view that the English common law took, and that was that intertidal lands were held by the public, held by government in trust for the public, and were open to a wide range of uses, and the title to those lands was held by the public, much like the public lots are held by the public. The paper companies thought they owned them for a while because they'd been cutting the timber for so long, but the courts ultimately said, no, you get to cut some timber, but that doesn't give you ownership.
But I thought previous court rulings on this issue of ownership of the intertidal lands, I thought that had already been settled. You're saying that it's still an open question, or not?
Well, I want it to be an open question. The fact is, in 2 decisions, they're sometimes referred to as the Moody Beach cases. That's the actual beach in which a group of upland owners made a claim that we own this beach area. The first of those 2 cases was decided in 1986, and the second of those 2 cases in 1989. But those 2 cases said that early Maine cases had followed Massachusetts law, and that they felt constrained to continue following Massachusetts law. But Massachusetts law was predicated on a colonial ordinance adopted in 1647. A lot has changed from 1647 to today. The issues that were important then, fishing, fouling, navigation, lateral passage, not unimportant today, but less important today. Activities like seaweed gathering and recreational uses of these lands are important economically to the state, and most Maine people felt that the intertidal lands did belong to the state. The courts, though, held that no, Maine came out of Massachusetts. Early Maine cases adopted Massachusetts jurisprudence, and we read the ordinance to be the peg on which Massachusetts hung its hat, and we'll hang our hat on the same peg. But I think there's a lot of events that happened between 1647 and today that dictate a different outcome.
So are there a lot of cases that come up where people that own a house on the beach have gone into court to try to keep the public out of their space? Is that still a frequent problem?
Well, it's less of a problem today as a result of the Moody Beach cases. They feel like their point of view has been accepted by Maine's courts. Whether other states would hold differently, and as I indicated, every other state, every other coastal state, and with respect to navigable waters, all of the states that bound the Great Lakes take the view that the bed, the underlying land, is held by the state, and that the alienation, the ceding of title, particularly if it is all the intertidal land in the whole state, is given away to upland owners, is simply an abdication of state responsibilities. If you go back 1,500 years, Bruce, which I do in an early chapter of the book, just to get a historical perspective, intertidal lands and the ocean and air and water, fresh water, were held to be incapable of private ownership because everyone understood that settlements, civilization, populations, cities were dependent on access to the ocean. There were no cars and trucks and trains and planes. There were boats. There were people who built even when they were at war with one another. War was war between my armada and your armada. And so the intertidal land was the interface between dry land, upland, private property, and commerce, military activity, settlements in other parts of the world. Columbus got here on a boat. He didn't fly a plane, and so we moved from these early views of the necessity of everyone having access to and a right to use intertidal land, to Roman law, which embraced those views, to English common law, which embraced those views, to somewhere in the 1600s, we began the settlement of North America, and these occurred in various places as far south as South Carolina, and as far north up through Virginia, up through Maryland and Delaware and New York and Boston.
I would imagine that most people in the public would take your position on this, that Maine's beaches should be and are public property, I think.
Well, as recently as the 1970s, we passed a piece of legislation, the Submerged Land Act, that reflected the views of the then governor, Brennan, the views of the legislature, both chambers. They weren't as divided as we seem to be today. Nearly unanimously took the view in that act that small pieces of state-owned intertidal land could be given to upland owners, primarily in port areas, the ports of Portland and Searsport and Machiasport and Belfast, for commercial purposes. But if we take all of that acknowledgement that small pieces of intertidal land could be used and filled as necessary to build wharves and warehouses and gantries and the modern tools by which ships are loaded and unloaded and containers are put on 18-wheelers or on railroad flat cars and and the commerce of Maine and the commerce of the nation, whether you're in ports in the Great Lakes or whether you're in ports in Oregon or Seattle or Los Angeles or in the Gulf Coast or right up the eastern seaboard, can be carried on, but that would leave the lion's share of intertidal lands. I mean, these port areas that are necessarily filled for marine commerce represent 2 or 3% of the land between mean high and mean low. And if you add in the islands of Maine, where we've got thousands of islands, you get even a smaller percentage that are needed for marine commerce. So,
how did you get interested in this particular issue? There's so many different legal issues out there that you could have, really.
Well, it kept coming up. It kept coming up. We have in certain parts of Maine, we have an important recreational industry that millions of people come up from areas to the south of us to not just eat lobster, but to visit Arcadias and to visit in Ogunquit and York and in the Old Orchard Beach. Canadians come south and Philadelphians and Bostonians come north, and it's a big part of our economy. And the use of these beach areas for recreational purposes became important. They didn't come to be told by an upland owner that you're on my private property. And the legislature in the 70s clearly thought that these intertidal lands were publicly owned, and it wasn't until a group of plaintiffs in the Moody Beach cases, the formal name is the Bell cases, but the beach itself is Moody Beach, and it's in Wells. But my point is that it kept coming up over and over again. Eaton, aspects of it came up again in Cape Elizabeth. It came up in Washington County. It's coming up in the form not of recreation, but of the form of the economic value of seaweed today. You talk to people on the Maine Seaweed Council, and the average person thinks, well, seaweed is seaweed is seaweed. But there's 15 different discernible species of seaweed that are now being harvested in Maine and used for a variety of fertilizer and medicinal and other purposes. And you go down to your garden supply thing and you can buy a bag of these materials that are nutrients for garden soils and so forth. These are big industries, and they're getting bigger. They're not shrinking. Yeah. It's not like fishing where we overfish. We don't need to overharvest. The seaweed grows like seaweed.
So they need uninhibited access.
They need access. It needs to be regulated. Just like in the woodlands, you've got some people that overcut, that overharvest, and so you need some state regulation, but they're prepared to deal with reasonable state regulation. They don't want to overharvest, and they don't want the bad apple in the seaweed harvesting barrel to make it impossible to come right back to some of the same areas that were harvested 2 years ago, 3 years ago. Not like trees. They grow over 30 or 40-year cycles. Most seaweed grows over 2 or 3 or 4 or 5-year cycles, and so there'll be some regulation, but they certainly don't want to be told by an upland owner, you can't cut on my land because that seaweed is growing on this intertidal zone, and unless you get a license from me and obey my rules, well, the industry would just dissipate because this guy would have one set of rules, and this guy would have another, and this guy would have a third. You can't run an industry that way.
I've experienced this myself. Lincolnville Beach, walking along the beach, heading north along the beach, and I came across an area. I didn't know it was, supposedly private, but someone was very unhappy that I was walking on their beach. Yeah. Now I don't know if that particular spot was public or private, but they they made it quite well known that they were not happy with me being there.
Yeah, well, if you look to our sister state, whose rules of law we followed in this matter, it's almost all the beaches, save for a handful that are now publicly owned, where the public has actually acquired the beach. It's very privatized.
You're talking about Massachusetts.
Massachusetts, yeah. And the level of privatization will increase in Maine if we don't re-examine these cases. The point that Maine courts forgot in the 80s is that when Maine became a state, it was a sovereign entity and on an equal footing. There's a doctrine that springs out of the United States Constitution called the equal footing doctrine. And it's because we weren't going to have any second-class states. There were 13 original colonies and 13 original states, but states that were going to be created as settlement moved west. They were going to be equal in every respect. I brought
so
along...
you have 2 chapters in your book about this,
yeah,
right? This
yeah, the equal footing doctrine has its roots in the early 1800s, and the most recent equal footing case was decided only less than 10 years ago. And in all of these cases, let me just read you one passage from a case called Pollard. Well, I'll go back even further in time. When the revolution took place, the people of each state became themselves sovereign, and in that character hold the absolute right to all of their navigable waters and the soils under them. Now, this is the Supreme Court of the United States talking. The equal footing doctrine has sustained that provision of the U.S. Constitution for over 200, close to 200 years now. And over this period of time, various old Spanish grants, old English ordinances are sometimes put forward, and what the court has really said is that when the revolution came, these colonial grants, whether from Britain or Spain, became a nullity. There was a new nation. The 13 colonies became the 13 states, and those states adopted English common law. And English common law held that the Parliament and the King jointly, the executive arm of government in the King and the legislative arm of government in the Parliament, held title to intertidal lands, and private property began at mean high and went landward. And save for the same type of exception I was speaking of a moment ago, where you need and have the opportunity to have a harbor, to build a port, to engage in maritime commerce, then you could alienate some of the submerged land and some of the intertidal land so you could wharf out, so you could build a type of larger commercially necessary facility to berth the ships of that era. And
let's pause for just a
Sure.
moment. I want to reintroduce you. I'm speaking with Orlando Delogu, a retired professor from the University of Southern Maine Law School. He's written a new book called Maine's Beaches Are Public Property. Orlando, I wonder what's your strategy behind the book? Are you trying to educate the public, or is this a political effort in order to keep the issue alive? Or?
It's a little bolder strategy than just educating the public. I think that's an important step. I think large segments of the public believed for decades, if not longer, that Maine held title to its intertidal lands. When the Bell cases held otherwise, there was a sort of collective groan. What does that mean? And can we go on these beaches? Well, some upland owners continued to allow people on their beaches, but some, like the person you were engaged with in Lincolnville, not so sure they wanted you there anymore. And so exclusions began to crop up. Some public ownership grew as a result of these cases. But by and large, I've taken the position in the book that the cases that Maine, that the two Bell cases and the line of reasoning they relied upon represent judicial errors, represent the failure to take into account the equal footing doctrine, the failure to take into account the fact that the colonial ordinance itself didn't directly alienate all intertidal lands in Massachusetts. An interesting phenomena came to the fore in just a recent case, and that is in the settlements by Massachusetts of areas in Maine. The Massachusetts legislature, well after the colonial ordinance, well after, gave title to property to new settlers, and in almost every instance, the title ran just as it did under the common law. It ran from mean high landward. They preserved in these early settlements in York, in Wells, in North Yarmouth. And North Yarmouth then ran from Portland all the way up to Harpswell. So that was a big chunk of land, ran from mean high landward. The intertidal land, there was no Route 1, there was no 295, there were no cars and trucks and trains. In fact, there's a section of the earliest trains available in Maine that was on the beach in Wells, because that was the thing that you could publicly owned, where it was close to, and in cases ran just above mean high, but it was subject to some flooding. But my point is that I think Maine followed Massachusetts off a cliff that it didn't need to follow.
So let me ask you this. With that being the case, is it too late now? Is this too locked in to...
Well, some would argue that. But interestingly enough, the Supreme Court has never taken that position. The Supreme Court simply... there was a case, Phillips Petroleum, that was decided between 1986 and 1989 by the U.S. Supreme Court. And in that case, it was down in Mississippi. It involved some early Spanish grants. The upland owners there had said, we have relied on these early Spanish grants to claim ownership of the intertidal lands for 171 years. And the Supreme Court of the United States wound up saying, your use of those lands was acquiesced to by the state, but that didn't mean you owned the lands. It's a lot like the reasoning that our own court took with respect to the public lots. Your cutting of timber didn't give you ownership of the underlying land.
So where's the resolution? Is it in the legislature or is it in the courts?
I think it's in both. I've urged the courts to re-examine. The present Chief Justice, Ms. Softly, in one of these interim cases, a case called Eaton, she frankly urged her colleagues then to re-examine the Bell cases. She said the Bell cases were ill-considered. I'm saying the same thing. I echo what she put in a concurring opinion.
So how does the public...
Well, I think the public needs to know that there's a strong argument to be made that Maine, upon becoming a state, gained title to its intertidal lands. Maine has not given away that title to anyone. It has allowed small areas to be ceded to an upland owner, but it has not given away all of the intertidal land in the entire state. And that's what Massachusetts is deemed to have done under the colonial ordinance. Can these arguments be made in Massachusetts? Some of them can be. It's been a longer period of time there. But the Supreme Court has simply said 171 years after the Spanish grants, The title is in the state of Mississippi. We confirm that title. That's what the equal footing doctrine is all about. Every state, when it joins the Union, is on a parity with the 13 original colonies, then states. I want the law court to re-examine it.
What could the legislature do?
They could bring a lot of pressure to bear on the law court. They could make it clear that no legislation, they could ask the Attorney General's office to file a declaratory judgment proceeding. They could clearly expand the uses, exercising their police power. They did that in 1986, but the Second Bell case declared that legislation, which expanded public use rights to include recreational and lateral walking along the beach.
So what happens to all of this as global warming continues, worsens, as we have rising sea levels? What do you think is going to happen then?
Well, I think it's going to change the shape of every coastline on the face of the earth. The areas that are dry sand today will be tomorrow's marshlands and intertidal land.
But it's going to have all kinds of legal ramifications down the line, isn't it?
It may. People may find that the whole of their property is underwater. It's submerged land. It's not even intertidal. It goes from upland to intertidal to submerged. We will reconfigure things like Camp Ellis, which we keep trying to salvage. It's right on the edge of being intertidal now.
It would seem to me that the state legislature should begin now
moving things back,
getting ahead of this thing before it...
Clearly, you're clearly right. And a part of me has written a lot of words over the years in law review articles and in public papers saying that we keep putting things in the wrong places. We keep putting things in the paths of hurricanes, in the paths of sea level rising. Anyhow.
Well, we only have a little less than 2 minutes left. I wanted to ask you about the recent General Dynamics corporate welfare bill. You were heavily involved in that effort. Yeah. You wrote extensively about it. General Dynamics asked the state for $60 million. Because of the campaign, we were able to cut $15 million off of that. Finally, they got $45 million. What's your final take on the whole effort?
I think it's corporate overreaching. I think they squeezed the Maine legislature. They played on their fears. But Bath Iron Works isn't going anywhere. They made $3 billion last year. $3 billion, Bruce. They have a 10-year backlog of work. They have a trained workforce. They have a work site and a shipyard that is modern in every sense of the word. It's on a major river system where global warming will not affect as early as it will other areas to make it so wet and inundated that the work site is inoperable. We didn't need to give them money. They're rich enough. They pay their corporate leadership $21 million a year in salary, and they're squeezing Maine taxpayers. We're a blue-collar state on the whole. They're squeezing Maine taxpayers for $45 million. It's just corporate greed run amok.
Yeah. Well, thank you for being a part of that. Thanks for coming on the show.
Thanks for having me, Bruce.
Orlando Delogu, pick up his new book, Maine's Beaches Are Public Property. I think everybody should be interested in this subject. Beautiful picture of Sand Beach?
Sand Beach up in Acadia.
Acadia. And thanks for watching another edition of this issue. Until next time, good luck to you all, and please get organized.